Hello, everyone. To those of you who have joined us on time, thank you. We're going to give everyone who is uh, signed up but not here yet a moment of grace. I have a timer going. Once we reach the end of the timer, we'll get the webinar formally started. Thank you for showing up, and we'll be talking soon. All right. I know the timer didn't run out, but we are 3 minutes past the hour, so I'm going to get everything started. Thank you very much to everyone for joining our webinar today about new H-1B rules and how USCIS is adjudicating petitions and late breaking news on changes to adjustment of status. So let me just tell you briefly about who we are. If you are new to Meltzer Hellrung or you don't work with us yet, we are a business immigration firm that really focuses on melding technology and service together. We have our own proprietary technology. We have really focused on service and program management. We work with large corporate companies as well as small companies, entrepreneurs to the biggest companies. We've been recognized in a lot of different places. In Inc. for Power Partners, uh, we are listed in Chambers, and in 2023 we were also listed as one of the 100 plus places to work in Chicago. In terms of what we do for service, we really focus on measuring how we're doing. We ask everyone how we're doing every single case. In 2025, we had an NPS score of 91. We measure our email response time. Our goal is 1 business day response time on every single email. In 2025, our average email across the firm was 4.5 hours. We look to make sure that the things that matter as fast occur fast. And so that means new work authorization. So when someone is doing a transfer, a change of employer, we are able to turn that around in 10 business days or less. And we are thinking much more about the program as a whole, not just every single application. Not that applications are unimportant, but our goal is to help employers attract and retain the best talent. And so that means thinking about immigration comprehensively about how do you make a program that's efficient and effective. Our services go well beyond just filing for visas. That's the core of our work, but we also are able to help employers with global immigration. So, immigration to non-US countries. Currently, we help employers in countries including Ireland, UK, Canada, Mexico, Turkey. France, and we are always happy to help, whether it's a visitor visa or a full work authorization. We're helping with the consular processing and interview preparation as consular processing gets more challenging. We think it's more and more important that employees and individuals have counsel to be prepared for that consular interview. We help with I-9 and compliance, including audits of I-9, public access files, immigration policy, and we're able to help with litigation. That means if there's a delay or there's an outcome in a case that seems particularly unjust, we're able to show up in court. And last, we were able to help staff. More and more companies are thinking about how they handle the immigration function, how they handle mobility, who handles it internally. We're able to help with that staffing. You're hearing from me right now. I'm Matt Meltzer, one of the co-founders and managing partners at Meltzer Hellrung. I do a lot of things here, but I love working with companies of all sizes, but especially scaling companies and newly founded companies. And my colleague, Michael Taranzik, is here, and I'll let him introduce himself. Mike, I'm handing it to you.
All right, thank you so much. I was on mute before. So yeah, thank you, Matt, and thank you all for being here today. As Matt said, my name is Michael Terensky. I'm senior counsel at the firm. I've over 30 years of experience in employment-based immigration law, representing all the way from startups and entrepreneurs to Fortune 100 companies and everything in between, and really having a focus on policy and immigration, immigration legal issues over the past several years.
Great. Just quickly, Voyager is our proprietary tech platform. It allows employers and employees to really know what's happening in the process, so they can answer as many questions without talking to an attorney or paralegal as possible about where we are in the process, what is needed, who will take action next. It creates a very clear narrative of a case, and you're able to provide reporting on a company-wide basis about where your entire population is at. All right, today we're going to talk about a bunch of different things. Everything from what happened in the 2027 lottery. We got data now from USCIS on what that looks like, about the late breaking adjustment of status memo that came out Friday. Thanks for making our weekends much more difficult, USCIS. New data on H-1B petitions and what it means, what the USCIS is requesting, and how that's going to impact RFEs, LCAs, petition building, and being ready for additional scrutiny from the USCIS, and then proposed regulatory changes on the LCA. Mike, with that in mind, I'm going to hand it off to you to take us to the next piece.
Yeah, thank you. And we can just move ahead to the next slide. I think one thing I do want to say, we added a couple of slides here. This might be our last slide for a while, sort of a postscript on the H-1B registration process. But before I start on this, one issue that did not make it into the slide deck that just came up late last week is that for the employment-based second preference category, the entire allocation of immigrant visas for Indian nationals has been utilized for this fiscal year. So if you have employees who are applying for employment-based second preference visas and they're from India, there can be no more approvals for the rest of this fiscal year, which runs until the end of September. So the good news is a lot of people in that category got green cards this year. So they fully utilized their allocation, unlike some other categories such as EB-5, which are very unlikely to use their full statutory allocation. But the bad news is we've got 4 months where there'll be no more approvals for individuals in the EB-2 India category. Okay, so moving on to the H-1B fiscal year 27 lottery. USCIS announced recently the data. And for those of you who haven't seen it, there were a total of 200,600 registrations this year. Pretty significant drop from fiscal year 2026, over 132,000 fewer applications. So it's a 38% drop year over year in registrations. Some interesting data is that this year, 71.5% of the individuals hold a U.S. master's degree or higher. So a pretty significant jump from prior years. So if you're wondering whether that weighted selection system works, it looks like it clearly skewed the registrations towards the higher wage level type positions for which a U.S. master's degree are higher. And as you can see, the selection rates, they also, USCIS also provided that information. Largely what we expected. Level two, I think, came in a little higher than many of the people who've been following this closely predicted. But for the most part, the selection rates came in pretty much as predicted. Now, we experience approximately a 50% selection rate. A lot of other practitioners, just from what I've heard in the immigration community, had about a 50% selection rate. So what we can infer from that is that approximately there were 106,000 selections made for the 85,000 visa. And again, that's not unusual. USCIS has historically always selected more registrations than it can approve in terms of H-1B petition to account for withdrawals and denials of petition. So they've sort of booked an additional approximately 20,000, estimating to account for denials and withdrawals. So again, it looks like the weighted selection system discouraged lower salary applicants from registering. And one question I've heard from clients and other practitioners is, what do we think? Is there any possibility that USCIS will conduct another selection round? And for me, at least, that question comes down to, what do you think? If you believe that the pool of applicants this year is likely to be more qualified because they have, again, higher level degrees, higher level salaries through the weighted selection system, higher level degrees, then maybe there'll be fewer denials and maybe there won't be an additional round of selections.
Hmm.
But
I don't think
alternative,
that
yeah,
in terms of who the employers are, Mike,
yeah,
drop is, I think that the biggest discouragement was not the wage-based leveling, but rather the $100,000 litigation fee,
yeah.
$100,000 entrance fee, which discouraged anyone sponsoring people from abroad to file. I would expect that if that rule is struck down before 2027, that we'll see an increase in registrations in 2027. That might be quite significant.
Well, that's an interesting, I mean, that's an interesting point because there also could have been people who are registered in anticipation of that rule being struck down. So there could be individuals who are, waiting to see if before June 30th there is a decision from the federal court on that issue, which would enable them potentially to file. So that's another part. But the last point I wanted to make on this is that, there's a lot of additional scrutiny going around the H-1B category. And if that scrutiny leads to more denials and more withdrawals, then there is the chance that there could be additional round of selection, keeping in mind that hope is not a strategy. Right now, it's not easy to say, but I think there are some factors working in both directions. So go ahead. If we can move to the next slide. Thank you.
A nice,
Go
nice
ahead.
issue that came out right before a holiday weekend. There,
Yeah. So yeah,
yes.
USCIS has a history of doing that. They've done a lot of, the $100,000 fee was announced late on a Friday, and it sent the immigration community scurrying. This one, the actual policy memo was written on late on the Thursday, but no one heard about it until some news articles started popping up in the internet about it, Friday morning, and that just caused a tidal wave of emails, listservs, and social media sites everywhere. We're talking about it. And then finally, the memo came out late Friday morning. But what it did was that it was a memo that quote unquote reminds officers that adjustment of status is a matter of discretion and quote administrative grace. It's not a right, and this is the position of the current USCIS leadership. It's not a right. It's an extraordinary benefit, and that even if all statutory criteria are met and you've proven that you're otherwise eligible for adjustment, that is not, that may not be enough. Officers are instructed that they can still deny a petition even when all statutory criteria are met. Now, there has been no guidance on this. I mean, I just think when I've heard from other immigration lawyers and heard what other, immigration officers are saying, um, it's clear that there hasn't been any official guidance provided yet on this. But what is clear so far is that officers are um, required to look at, and really instructed to look more carefully at prior violations, prior immigration overstays, whether consular processing abroad was a viable option, which is a question that's now essentially being asked at all in-person adjustment of status interviews, and looking for any activity by the applicant which may be inconsistent with their immigration status. And again, highlighting the fact that officers are are not precluded from denying an application. I have to pick my words carefully. Officers are not precluded from denying an application, when just because there are no negative factors. They're really requiring applicants to show that they are eligible for a favorable exercise of discretion. Let's go ahead, Matt.
Yeah, I would just note, Mike,
Yeah,
this is something that is for sure going to be challenged in court. Um, the memo is exceptionally vague. Like it's very unclear what rules the government is implementing. This is a enormous change in policy from the way things have been adjudicated for decades, which, anytime you make a giant shift in policy and you don't regulate it, that leaves you open to a lot of legal questions. And this whole idea that it's an extraordinary right when Congress has again and again built statutes that uh, privilege adjustment of status as something fairly ordinary, um, it is, I think it's a poor interpretation. So I think it's going to be subject to a lot of scrutiny, both from potential challenges on denials and from facial litigation. But let's start with what hasn't changed.
yeah, absolutely. I think it was a poorly written memo with conveniently quoted case status justification for the policy, and it was really results oriented policy making. So they knew what they wanted to do, and they tried to build the policy to accomplish it. So, but what hasn't changed? So there hasn't been any, as I said before, there hasn't been any guidance provided to any of the field offices conducting adjustment of status interviews or adjudicating adjustment of status applications. Just like the gold card, just like the $100,000 H-1B fee, just like some of the changes to the I-129 that we'll be talking about in a few minutes, the White House and DHS promulgated this policy without any instructions to the field about how to implement. So adjudicators are right now conducting interviews. They're asking questions about, so why didn't you, pick consular processing to pursue your green card? Could you still process through consular processing? Would you like to change and process through consulate abroad? But they're not really asking any specifically consistent questions across all jurisdictions and in all circumstances. And in fact, officers are essentially holding cases in abeyance, waiting for some formal guidance from headquarters on this. So that's what's happening on the ground right now as of the last few days in terms of this policy. What I think that it shows is that applications can still be approved. Adjudicators are still looking at applications and are willing to approve them. It's just now that they are having to do more of a weighing analysis, in terms of determining, based upon a totality of the circumstances, whether an applicant is eligible for adjustment of status. That then leads to, I think, a corresponding consideration of what positive factors will an applicant demonstrate to an officer to show that they merit a favorable exercise of discretion. And you can see them on the screen. I'm not going to go through them in any great depth, but I think what this has done is that it has added an additional layer of preparation for applicants for adjustment of status, both in terms of the application that might be submitted as well as what might be happening at the interviews. Now, strategically, until there is some clear guidance, I wouldn't encourage anyone to start developing folders full of positive factors right now for their applications. They should be thinking about it, but until we know what the policy is going to require, we probably want to see, and hold and see in terms of what documentation applicants should be developing.
Yeah.
It is important to note. Oh, go ahead, Matt. You want to
I
talk?
was going to say that the vagueness here that where we are in the dark, the challenge is that the USCIS officers are in the dark too.
Mhm.
They don't know what they're supposed to be asking for. And so I think everyone's going to be sort of bumping around for a little while trying to figure out what the new normal is, if this, while this policy is waiting to be challenged or is challenged. But I think that, at least from my perspective on the employment side, the way this memo read to me, Mike, was that it is targeting family-based petitions first and employment petitions second. Doesn't mean that we shouldn't be careful on employment petitions, but the person who's being sponsored by an employer is inherently has the kinds of ties that are beneficial to the U.S. that in the employment relationship, benefit of economic benefit to the country. All those things are positive, especially if the person already has a U.S. degree as well.
Yeah, yeah, no, I agree. I mean, in fact, subsequent to some of the clamor, outrage that has been experienced on this issue since it was announced on Friday, USCIS, I think, has started to walk back some of its initial statements and indicated that things like economic benefit, like serving in a capacity that's in the national interest, will be, I think, beneficial in terms of making it a favorable consideration. Last thing I want to say is that while dual intent categories are specifically called out in the memo, I think they also will require some thought going forward as to what documentation of positive equities they have as part of the application process. But again, TBD.
Yeah.
So the main issue, the headline issue of our presentation today is these additional questions that were added just before this H-1B cap season for USCIS to collect additional data about the H-1B petition. So here are the questions taken right from the form. Um, as a practical matter, questions 7 and 8, they're routine. They're normal questions asking about what is the level of education required for the position, what are the fields of study that would qualify someone for the position. That's normal. To qualify for an H-1B, you have to have professional level credentials in a specific specialty that relates to a professional level job. That's paraphrasing it, but that's essentially what is at the core of an H-1B petition. And you're paid the required wage for that particular job. So those questions are not particularly novel or problematic. What what is a little bit more potentially challenging are the questions 9, 10, and 11, because they're really they're new questions, obviously, and they don't really relate to whether a person qualifies for an H-1B specialty occupation based upon that very broad definition that I provided. So, you don't have to have experience. H-1Bs can be entry level. There's no specific requirement of particular skills that are statutory prerequisites. There's no reference to that. And there's obviously no reference to supervision, particularly if entry level positions are required. Let's move on.
Yeah.
Keep things moving. Um, so why were these questions added? Well, certainly, if you've been in this area, if you practice in the immigration career, if you're working in this area, if you're a stakeholder, you've heard for years about the allocations that the H-1B program is subject to fraud and abuse, that U.S. employers are hiring workers at lower wages than American workers and undercutting the U.S. workforce. So that is sort of the backdrop of some of this is happening with this administration. In addition to that, there was a regulatory change that happened in January 2025 that provided USCIS with greater access, the ability to question prevailing wage and LCA determinations in the H-1B process. And these questions are a manifestation of their efforts to get the data to perform that analysis and those investigations. So they're looking, they've mirrored the prevailing wage level factors that are used to get perm applications filed and approved. And they're also going to be looking at this both retrospectively and prospectively. They're going to be looking at the registration forms, they're going to be looking at the H-1B petition, and very likely, right, very likely perm applications.
Yeah.
So go ahead, Matt. You wanted to comment?
And I just want to note a couple things before we keep going on this conversation, Mike. One is that the if you have questions, please put them in the Q&A
Hmm.
function. Mike and I will try to get to any question we can, whether live or in writing, during this webinar. And if you came in here not anonymously, as in named, and we don't get to your question in this webinar, we will follow up with you after the webinar. So please, we welcome your questions. We want to hear what your thoughts are about what's happening. Um, but Mike, I would just say that th this change, we talk about what is happening here. Like this is a major shift in terms of what USCIS is asking for. Previously we only provided just a degree. We never listed anything about experience, skills, or supervision. One thing that's really important to know is that we haven't changed how we're filing yet. We're waiting to see if that when the hammer is going to drop. There have been a circulation of a couple of RFEs, and by a couple I really mean like a handful of RFEs in the entire immigration lawyer community that people are aware of. But we are still responding just with the degrees and degree required, because until we start getting RFEs, we're loath to provide more information than they're going to adjudicate. And we're getting approvals.
Hmm.
We are getting approvals on transfers. We're getting approval on cap cases. So without a doubt, they will start formulating more specific RFEs. But until it becomes a clear trend, we're not going to be providing more data than we have to,
Right.
because the more that we provide, the more that they can compare over time. So if you are looking at your petition, if Meltzer Hellrung is working on it, you're saying, well, you didn't provide any experience or skills in it, uh, that's intentional. We are intentionally keeping the petition limited until we are forced to do otherwise.
Yep. Two quick comments on that, Matt, and then we can move on. One, which is, we're trying to keep our clients' options open for the future. So not being terribly specific when it's not required by statute, I think is providing our clients with greater facility to make changes, to make adjustments down the road. And secondly, the only applications or the only petitions that have been subject to RFEs so far, to our knowledge, have been ones where they've included that information. They provided that extra detail. And USCIS has asked questions in an RFE, and we'll talk about that maybe in a few slides. So,
Yeah, and
go
and I
ahead.
think it's helpful here, Mike, to just talk about the context of what we're thinking about. Um, we with the AI tools that everyone in every
Hmm.
business is starting to use, we recognize that the AI tools uh, are equally impactful on the government, and what they can do and how they see data. And so we are expecting that in time, the government is going to start comparing petitions for the same individual. So from an initial petition to an extension, if it's the same position, what is there? And then similarly, like petitions across an employer. So if you
Hmm.
routinely, as an employer, sponsor petitions for, say, a software developer, what are the requirements being listed on that petition? Are they consistent from individual to individual? And so, we're looking to ensure that we're creating consistency. Some employers already do this by default. Some employers have hyper-specific job descriptions that they slot people into, and they know that people qualify before they even start sponsorship. Other employers have much more vague job titles and descriptions that they slide people into that have a lot of flexibility. And so if you're the former, you have a hyper specificity, you probably have not a lot to worry about here because you're already doing it. If you are an employer that has a lot of flexibility in job titles and job descriptions, we're probably going to start pushing back on creating more specificity.
Right. And you absolutely, your initial point about data analytics and use of AI is actually spot on. As we've discussed in prior webinars, DHS has $1 billion contract with Palantir to help them with data analytics and the use of AI. And this is part of creating a long-term sort of data set for them to analyze.
Yeah. So, a couple of things here. Brittany asked about like, how are we creating consistency? A couple of things here that like we are, the legacy applications are what they are, but we're going to make sure that we're trying to align those as best we can. there's a sort of like a legacy debt here of things that could create liabilities that and other attorneys probably didn't worry about in the past. We are much more concerned about applications now and in the future going forward. But there was also just a question of like, what does a strategy look like? Is it, are the petitions for H-1Bs and green cards the same? Do you list the same job titles? Are those going to be different job titles? Perms are for offers of future employment. So there's no actual requirement that the perm and the H-1B have the same job title and job description. It might make sense that they don't, so that you don't create any consistency issues between those two things. So it's really going to be employer specific, and the level of risk for the employer is going to depend on the size of the program and how many people are employed. An employer who has 5 foreign national employees probably has very little to worry about. There's not enough data to try to create questions of consistency. The employer who has 500 foreign national employees probably has a lot more data to make sure that there's an alignment. Mike, so you want to take a moment here and sort of walk us through what actually prevailing wages are and how the DOL theoretically says they're supposed to be calculated?
So yeah, I think there are several factors that are core to this. One of which is um, getting the right occupational classification. So picking the right job within the standard occupational classificational code system that the Department of Labor uses to determine the right job, and that's based upon the employer's job duties. Emphasize that it's the job duties, not the job title. And employers can get in trouble if they rely solely on matching job titles because the Department of Labor looks at job duties. And this is really the core of driving the wage determination. So having the right job, having the right area of intended employment is next, making sure that you're picking the right location, because all of the prevailing wages that are done in the statistical analysis are specific to a particular geographic area. And then the next part is really determining the right wage level. And there are 4 wage levels, basically entry level, qualified workers, experienced workers, and fully competent workers. So there are 4 levels, and there is a very specific calculation process, and it's shown here on the slide. This is actually just sort of an excerpt from a memorandum that the Labor Department issued many, many years ago to help employers and immigration attorneys calculate wage levels and to determine whether you're again entry qualified, experienced, or fully competent. You do this analysis for every job. So as you can see there, every job starts at level 1. Then it goes to years of experience, and you can go up another level or maybe another 2 levels there. Education, the same. If it's more than is required in the standard occupational classification system, then you get extra points. Ultimately, you do the math, and you come up with the total sum of level points. And if it's 4 or more, you're level 4, which is the highest wage level. So,
And one thing I just
go
want
ahead.
to note, Mike,
Yeah,
on this is
yeah.
that in the H-1B lottery registration, just as a reminder, people, we filed the wage level based on the highest wage level that is cleared, not based on the wage level that you could be filing at. The question on the registration is just what is the level that the offered wage would clear. So, if someone's offered $100,000 and a level 4 wage is $95,000, they clear the level 4 wage. That does not require you to file at level 4. I've seen a fair number of questions from both companies and employees asking, what's a discrepancy between what we're what was the lottery registration wage level and a wage level that's going into an H-1B. Um, we are going to make sure that even if we're not listing requirements in our petitions, that the wage level is still consistent with what requirements are or could be. So if you're an employer and you just hired someone who just graduated from a master's program and they have no other previous work experience for like a position in tech, that's generally going to be wage level 2. You're not going to be able to justify a level 3 or level 4 because that person doesn't have enough experience to meet a level 3 or level 4 wage as a requirement. So those are sort of like things that we will be thinking about and are thinking about to ensure that the uh, petitions are logically consistent with what is happening on the actual applicant.
Right. I no, I completely agree that, when you're looking at it, the wage level that was selected for the registration system can definitely be different from the wage calculation that you do based upon the job duties. I'm using this calculation worksheet. And I think that if you um, artificially change that and it's not based on job duties, you could be potentially running into trouble. Um,
Mike, so in terms of, what is actually, as we said, we haven't in our office, we have not yet received an RFE about these new questions, but there are some RFEs that have been issued and about these supplemental questions and what the employer is looking for. And so, we are building out new processes internally. You'll start seeing from attorneys and paralegals new questions about, as I said, at this point, we have not been filing any of this digital data because until we're forced to, we won't. Um, but we're going to start making sure that we have some of that data in our internal files so that we are able to respond to RFEs if they start coming in. But the RFEs are asking for much more detail, just like what is the education required? What are the experience required? What are the special skills? Like the things are on the petition. They're asking for more data on that. And to the point of this, like we also want to be thinking about what does the employer actually do in terms of advertising roles for the perspective of putting it out into the public from an AI perspective. Not only can the USCIS access data across petitions, but they can potentially access things that are public, you know, resources. So if you are posting your job requirements on a website or you're posting it on Indeed, that's discoverable too, and we want to make sure that we're not creating inconsistencies that we don't have to explain.
the other aspect of this, if I can just add, is that, and we've talked about this several times on our webinars, which is, the Labor Department, USCIS, several agencies, of federal government are increasing their on-site investigation. So, DOL through that Project Firewall that we've talked about several times, their site visits have been up, 48% year over year, last year over to this year to date. So they're looking at, what are the, in their site visits, they're asking questions and sitting down with employers and foreign nationals and trying to confirm whether the job duties that are described in the petition are consistent with the job duties actually performed, or the salaries that are in the petition actually being paid, things like that, in determining whether or not there are potential significant violations of the H-1B program.
So you're talking about getting ready for a site visit. Um, Audits, which could occur in person or could be remotely accessed by asking for more detail, whether it's an RFE or an agency induced examination like that Project Firewall, which Mike was talking about, can create, we want to make sure that we're creating records that allow uh, companies to survive scrutiny and don't threaten either existing employees or the ability to file in the future. And so, again, the risk here is going to be really dependent on two things, the company itself and its filing, and then even within the company, the positions that are being sponsored. Again, even if you're a company with a very large immigration program, if you have a position that there's only one individual in, probably, at least in my mind, I, Mike, I'm here happy to hear your thoughts. To me, that's not it's not worth expanding too much risk and energy on because the profile from the government is how do you try to create consistency across one person? The person is consistent. But the roles that you routinely sponsor for, though, then it's important to create consistency. And I think to me, the biggest thing is creating more consistency across categories and ensuring that categorical approaches are uh, consistent. What I mean by that is probably drilling down into data that, again, to use the example of software developer, it's probably too broad a job description if you have 100 software developers. it might make sense to have software developer one, software developer two, junior or senior, uh, or software developer for this specific project or item or set of responsibilities. So that you create more distance between positions, so it's easier to define them. With that, you have a smaller group of people in each position.
So yeah, actually, to get back to your question, I agree. I think what the government is looking for, what USCIS and DOL, they're looking for press releases. So they're going to be looking, to make examples of more commonly known employers. So the more H-1B petitions you have, the more potential that you have for having potential inconsistencies. I think those are going to be the primary areas of focus for the government. They want to make a big splash. Just like they've done with some of the press releases that they've done in the recent past. So yeah, I don't know where the line is. I don't think anybody really knows where that line is, and that's why I think it's prudent to make sure that you've got solid process in place. But I would certainly think that if they're looking to expand, the first sort of layer of that is going to be for the higher volume users, maybe companies that are more in the tech consulting sector and the like.
Yeah. Before we jump to DOL posts, is
Yeah,
there anything
yeah.
else, Mike, that you want to talk about in terms of this and how you're thinking about advising employers and creating this consistency?
Yeah, I mean, I think that there are a bunch of things to think about because there are potential pitfalls here. I think, certainly when you talk about consistency across an individual's petitions, in that set of circumstances where there is no change in job duties, between the initial filing and the petition extension, then it's really important to make sure that there is consistency across those two petitions. But there's also a potential issue there. So if someone has worked for you, for 3 years, and they're a software engineer, and they have worked in that capacity for 3 years. Um, there may be questions as to whether or not they're an entry level worker. If you gave them a level one, are they not a level two now because of their additional education and experience? Are they still working in that same level one position? So there are things that have to, there's depth to the analysis. As Matt pointed out earlier, there's also questions about consistency across petitions for the same company. The company is, the government rather is looking for consistency across petitions for the same occupation, right? So they're going to look at that and say, are you having the same requirements and same job duties for those positions across geographic locations? So you could have, obviously you'll have different salary levels across the country for potentially the same job, depending upon what the wage and what the labor market is. So, but are your requirements consistent across the job for the company? As Matt also mentioned earlier, they're going to look at what you post on LinkedIn for the job. They're going to look at where else you're recruiting for positions. And if your H-1B petition says this, software engineers 0 to 1 year of experience, and all of your ads say you're looking for 3 to 5 with a set of specific skills, that's the kind of information that they may be using to create, an RFE or an investigation. Um, and I think just an aside here, something to be mindful of is the fact that if they do an on-site inspection, there's going to be an inclination for the H-1B worker to say, yes, I have, I'm very professional. I'm the most professional person in this H-1B category because they're concerned that the government's going to think that they're not eligible for an H-1B. Sort of the backlash of that is that then they may call into question that prevailing wage determination. Maybe they will talk themselves into a level four wage determination when in fact the petition was done at a level two or a level three. So there's something to be considered there in terms of how people are going to be questioned at these site visits that needs to be considered. And site visits are often happening with little or no advance notice. Um, and then in terms of the perm application process, I think that we've covered that pretty carefully. There's going to be this longer term data analytics effort to take a look at occupational requirements across geographies, across occupations, and across processes as the USCIS gets more data and they're using AIS or AI rather to do more specific analysis.
Yeah. And I would just say that to, experientially, like especially at larger companies, global mobility can be somewhat on an island compared to the rest of the HR department. And sometimes they don't interact as well as you would like. If companies are posting more specific job requirements online, it's going to require that the global mobility and the HR functions get aligned. If, you know, currently your job posting experience as an employer is just saying uh, bachelor's degree and no other detail, there's no real reason to worry about misalignment. Like we can have more detail in an immigration petition than is being posted on generally, but if it's the reverse where your general posting for recruitment purposes has more detail than in your immigration applications, that's going to create more questions. Mike,
Right.
I'll handle the last part here, which is proposed changes for prevailing wages. The Department of Labor uh, has formulated a proposed regulation here to change the wage leveling that is used for the purposes of the H-1B, H-1B1, E3, and perm processes. So as Mike talked about before, there's four wage levels. The way that DOL creates these wage levels is that they take general purpose surveys of employers and their occupations across geographies. So that, what an accountant is paid in Chicago is different than what an accountant is paid in Charlotte or in Austin. Um, and so currently these wages are just based on percentiles. Level one is 17, level two is 34, level three is 50, level four is 67. It's really important to recognize that the DOL today, even though they have this wage leveling, has not ever asked about any skills that go along with these. They just are these wages just are about what the spectrum of wages for the occupation is. There's no actual indication that, because someone is paid in a level one wage, that's normal for entry level positions. Like there could be other companies that are paying more experienced people at that level. Um, and so they're proposing to change the wage levels up significantly, uh, between like 17 and 22% per level. This is going to create major issues if it goes through to especially on extensions. If someone is currently on a level two wage and you have to jump 18 percentage points on the leveling, functionally a level three wage, they may not be able to meet it. And this is it's a major issue that employers are going to be facing. One thing that can be done is filing LCAs earlier before this takes effect. We don't expect this new rule to take effect before July 1st when wages are changed by default. But you can lock in wages with an LCA filed now to ensure that you are able to take advantage of existing wages. Another thing just to be aware of is that this rule will, if it isn't changed in final rule, is for sure going to be challenged in court. There is not a lot of clear explanation about why these percentages are what they should be and how they should be changed. It's not clear why, without being more clearly allocated to experience that the DOL itself does not gather about it, whether those are appropriate wages for the wage leveling. Um, and it's also not clear that the wages that people are being offered today have any inconsistency with the market. So there's a huge number of issues here that the DOL is going to have to address in its final regulation if they end up publishing one. And whatever they do, if they say anything consistent with this, it will be challenged in court. But I do think it is wise for employers to be cautious and thinking about how they set up their wages right now for the future, and for as we get closer to the end of the DOL's fiscal year, which ends on June 30th, whether you should file LCAs early.
Yeah. Just a couple of comments, Matt. I think one, the timeline of this is that the comment period for this proposed rule just ended earlier this week. So DOL is going to spend some number of months reviewing all comments, and I'm sure there were thousands of comments submitted, so it's not going to be done in a short period of time. They're required by law to review and show that they've reviewed them in their final rule. So it could be 6 months or more before this rule is promulgated in the Federal Register as a final rule, and at that point, it will have a 60-day effective date, effective 60 days from publication. And I believe what that means is that these new wage levels will apply to prevailing wage determinations that are issued after the effective date of the rule. So from now until that time, it's the existing paradigm, that current percentile profile. So there is an opportunity to use them. If yeah, we could jump back just for a second. And I'd also say, as Matt said, this rule is probably illegal. I reviewed one of the major comments on the rule that was just submitted earlier this week, and there are Administrative Procedure Act issues with it being arbitrary and capricious. There's also the fundamental question, if you're concerned about fraud and misuse of the H-1B and the PERM program, there are already rules, there's already an enforcement mechanism. Changing the entire paradigm does not address the issue that there may be fraud in the system. It actually just negatively impacts everyone, including the ones who, those of you who are trying to do it the right way. And lastly, I would just say it also is going to encourage employers to look much more closely at private wage surveys because you can opt out of this paradigm by having use of some of the published major prevailing wage surveys.
Oh, thank you, Mike.
Yeah.
I realize there's a lot of information. There's a lot going on. There is no single answer for everything for every employer. Some of these discussions need to occur on a client by client basis. So if you are already a Meltzer Hellrung client, please talk to your attorney. The question of what the best path is and strategy and risk assessment and balancing existing corporate practices against where these trends are going is something that has to be balanced on a client by client basis. If you're not yet a Meltzer Hellrun client and want to discuss this further, reach out to Mike and I. Our emails are here. We would love to talk to you if this is something that you want to figure out how to navigate. Uh, but I would say that, we have not seen the crisis yet. Right now, it is a time for proactive strategic planning. The RFEs aren't piling up yet, but now it's sort of the calm before the storm. And so anything you can do to build strategic resilience, we think you should. All right.
Okay, well, I would just echo that and say if you have follow-up questions, please reach out to either of us. We're happy to respond to you as soon as we can. I think we've provided short answers to some of the questions that were posted so far, but if you require more detail, please feel free to reach out to us. We're happy to be of assistance. And
And
thank
I
you
just see in
for
the
hanging
chat
in.
request for the slides, just everyone, our standard practice says that everyone who signs up for the webinar receives the recording and the slide deck. If you want to see any of our previous webinars, they're all posted on our website in the resources page. So everything will be available to those who registered. If you want to see any of our previous discussions, please go onto our website, meltzerhellrung.com. All right, thank you very much. Thank you, Mike, and we'll be sure to be back in June for more discussion. Thank you, everyone.
Take care.